So we are starting with chapter number 5, the Limited Liability Partnership Act 2008. Okay. Now, what we are going to see in this chapter, it is different than your partnership act, like how it differs from your normal partnership, and what are the essential features, what are characteristics. In your examination, mock 1, they have asked you essential features of LLP, if I'm not wrong. So they can ask you some direct questions also over here, right? First is the introduction that they have given. When was this act introduced? How it came applicable? Is it applicable to whole of India or are there any exceptions? We'll see that. Ministry of Law and Justice on 9th January 2007 notified the Limited Liability Partnership Act 2008. So on 9th January 2007, they notified in a notification that they said that this act will be applicable from the financial year 2008. The Parliament passed the Limited Liability Partnership Bill on 12th December 2008. So it was passed as a bill. When a bill is passed, then it becomes an act. So, and the President had assented the bill on 7th January 2009. We have seen in the first chapter that a bill is proposed, then the assent of both the houses of Parliament is there, right? Both the houses of Parliament assent is required and President's assent is also required. So the bill was passed on 12th of December 2008. It was notified on 9th January, passed on, bill was proposed on 12th of December 2008 and the assent of President was received on 7th of January 2009, right? 7th January 2009 it was applicable. Then and called as the Limited Liability Partnership Act 2008. The name was given as Limited Liability Partnership Act 2008. The LLP Act 2008 is applicable to whole of India. This act is applicable to entire India. Has been enacted to make provisions for the formation regulation of limited liability partnerships. We have seen that the partnerships in the Partnership Act, that the partner's liability is unlimited. If the partners are not able to repay from the firm's assets all the liabilities that are due, partners may bring their own money. But in limited liability, what will happen? They will have a limited scope of their liability. They will not have to bring the money from their home to repay the firm's debts. And for matters connected there with to or incidental thereto. So this act is developed with forming the regulations, how one has to register the LLP, what are the provisions, laws applicable for LLP. All this is contained in this act. It has 81 sections and 4 schedules. First schedule with mutual rights and duties of partners. Rights and duties of partner. What are their rights towards each other? As well as limited liability partnership. So what are duties and rights towards partners as well as partnership and its partners where there is absence of formal agreement with respect to them. If there is no formal agreement between them, then also what are the rights that are the deemed rights you can say, or these are the implied rights you can say. Second schedule deals with conversion of a firm into LLP. If a normal partnership firm converts into LLP, what are the provisions are given in second schedule? Third schedule deals with conversion of a private company into LLP. Now we know that there are private companies. So private companies require minimum 2 people. So when 2 people are only required, they can also form a partnership. So they can convert their private limited company into an LLP. Fourth schedule deals with conversion of unlisted public company into LLP. There could be some public companies, but they are not listed on the Stock Exchange of India. So they can also convert themselves into LLP. Ministry of Corporate Affairs and the Registrar of Companies are entrusted with the Ministry of Corporate Affairs and Registrar of Companies are entrusted with the task of administrating the LLP Act. So the LLP Act 2008 will be looked after by ROC and MCA, Ministry of Corporate Affairs and Registrar of Companies. Central government has the authority to frame the rules with regard to LLP Act 2008. Who will frame the laws for it? Central government, CG, and can amend them by notification in the official gazette from time to time. Also, they have the power to amend the laws. Okay. It is also to be noted that the Indian Partnership Act 1932 is not applicable to LLPs. LLPs have their separate act, Limited Liability Partnership Act 2008, and that is only applicable to them. The Limited Liability Act 2008 has been amended through the Limited Liability Act Partnership Amendment Act 2021, dated 13th August 2021. So the like earlier the act was Limited Liability Act 2008, LLA Act 2008. LLA 2008 was then amended by Limited Liability Partnership Amendment Act. Limited Liability Partnership Amendment Act. Okay, 2021. Need for new form of limited liability partnership. What was the need over here? Lawmakers envisaged the need of bringing out a new legislation for creation of limited liability partnership to meet the contemporary growth of the Indian economy. Indian economy is dynamically growing. So for that, the lawmakers thought there should be a separate limited liability partnership act where the partners are willing to take interest in it rather than making a company, because in company your liability is limited. Similarly, they thought if we make something in the partnership, people will try to get more involved in the LLP Act. That is why the lawmakers envisaged the need for bringing out new legislation for creating limited liability partnership to meet their contemporary growth of the Indian economy. A need has been felt for a new corporate form that would provide an alternative to the traditional partnerships with unlimited personal liability on the one hand and the statute-based governance of the limited liability company on the other hand. Now, same as companies, they will be having limited liability. They wanted to overcome the traditional partnership which had unlimited personal liability. So to remove that unlimited personal liability, they tried to bring in the Limited Liability Partnership Act. In order to enable professional expertise and entrepreneurial initiative and combine, organize and operate in flexible, innovative and efficient manner, the LLP Act 2008 was enacted. It was enacted to enable professional expertise. People could become, like here mostly you see LLPs are formed by professionals. Architects will form an LLP. Your architects and civil engineers will form an LLP. Those who have got that professional knowledge, they will try to form it. Entrepreneurial initiatives, small entrepreneurs can enter into LLPs. Then they can combine, organize and operate in flexible, innovative and efficient manner. They can do work on their own basis, any flexibility that is required, the capital requirement, they can set as they want. Then innovation, new ideas also can be inculcated when they are working in LLP. Thus, LLP as a form of business organization is an alternative corporate business vehicle. Alternative of your company is LLP. LLP is your alternative of a company. It provides the benefits of limited liability but allows its members the flexibility of organizing their internal structure as a partnership based on mutually arrived agreement. LLP form enables entrepreneurs, professionals and enterprises providing services of any kind or engaged in scientific and technical disciplines to form commercially efficient vehicles suited to the requirements. As I explained you, like the professionals, your entrepreneurs having scientific knowledge, etc., can form the LLPs. So here we see that they have said that instead of forming a company, people have the advantage of making a partnership kind of work where 50, 40, 30% can be distributed among the partners, and they can avail the limited liability benefit in the LLP Act. Owing to the flexibility in its structure and operation, LLP is a suitable vehicle for small enterprises and for investment by venture capitals. It is a good option for small enterprises where 4 or 5 people are running a small business. They can enter into LLP. And for investment by venture capitals. Venture capitals also think of investing in LLP businesses, and they can also form a, venture capitals can also form a LLP. Okay. Now we have spoken so much about LLP. Let's see what is the meaning and what is the concept given in the. A LLP is a new form of legal business entity with limited liability. Liability in this case of all the people partners will be limited. That is very clear from the name of the act. It is very clear that the liability will be limited of all the partners. right? It is alternative corporate business vehicle that not only gives the benefits of limited liability at low compliance cost, because companies, if you form a company, the compliance cost is high. Compared to this, LLP takes less cost, but allows it partners the flexibility of organizing their internal structure as a traditional partnership. You can keep the internal structure as traditional partnership, like you can have your PSR ratio, you can still maintain how much is the capital is to be contributed. PSR can be there, capital contribution can be there, then your interest on capital, all these regular things can work. Along with this, one thing that is added over here is the liability will be limited. LLP is a separate legal entity, and while the LLP itself will be liable for the full extent of its assets, the liability of the partners will be limited. Now, if LLP is a separate legal entity, it is not distinct from the, it is not same as the partner. It is a distinct entity. Assets of the entity are the entity's assets. It is not assets of the partners. Liabilities of the company LLP are LLP's liabilities. It is will not be the liability of partners. Therefore, how much they have not paid, the capital not contributed by them, till that extent only the LLPs will be having the limited liability. Okay. LLP as a separate legal entity and business organization is an alternative corporate business. I told you, alternative to companies, you have LLP. That gives the benefits of limited liability of a company and flexibility of partnership. Now see, the words are going to be repeated. They have just tried to explain. Since the LLP contains elements of both a corporate structure as well as partnership firm structure, LLP is called hybrid between a company and a partnership. LLP, you can call it as a hybrid between company and partnership. Till here is the first introduction part and the definition meaning part clear to you all.
Yes, ma'am.
Okay, let me see the people who have raised their thumbs up. Okay, let's go ahead. Let's see what's further. So, nearly what we can see is the major benefit of forming a LLP compared to a normal partnership is that you get the limited liability. And this is a benefit why people were turning into small companies. So when the small companies was coming into boom, people thought that LLP is also a good advantage for us. And rather than going into company compliances, etc., we should be entering into the LLP business. That is going to be very easy and the compliance are simpler as compared to your partnership business, your company business. The compliances of formation, then you have to put the name over there in the company's register. Then you have to file the returns. The returns will be public. For LLP, it is not that you have to put the returns as public, right? For the public companies, you have to put the details. Then small businesses have the advantage of entering into LLP. So more or less, we learned that liabilities of the partners will be limited. New form of legal business is introduced by limited liability, and it is an alternative to corporate business vehicle. LLP itself will be liable for full extent of assets. No partners will be liable from their personal property. LLP will be liable. Allow the partners flexibility of organizing their internal structure. You can organize the internal structure as you want. You want to take a debt, you can take a debt. If you don't want to make other people as the capital, because in company what happens, you have to make share capital, then you have to give it to other people if it is a public company. So all these advantages are there for the LLPs. Body corporate, some important definitions will be seen. It means a company as defined in clause 20 clause 20 of section 2 of the Companies Act 2013. So body corporate is something which includes a LLP registered under this act, LLP incorporated outside India, and a company incorporated outside India. So your body corporate is a company and it will include your LLP, right? So LLP is also included in your body corporate. LLP formed outside India. Outside India, that will also be your LLP, and a company incorporated outside India. So that is called as a foreign company, right? But does not include. What does it not include? Let's see. a corporation sole, a cooperative society registered under any law for the time being in the force, and any other body corporate not being a company as defined in clause 20 of section 2 of the Companies Act 2013 or an LLP as defined in this act, which the central government may by notification in official gazette specify in this behalf. So these three things, these three entities will not be your body corporate. A corporation sole, a cooperative society, made by the people, like they come together and make a cooperative society. Any other body corporate which government may say like, okay, this is not a body corporate. Government gives the list, these companies or these entities will not be called as body corporate. So they will be excluded from being called as body corporate. Then the next definition that we have is of business. Business includes every trade, profession, service, and occupation, except any activity which the central government may by notification exclude. So any trade, commerce, profession, service you are giving, any trading you are doing, any occupation you are following, teaching as an occupation we are following. So dancing, like dance teachers, etc. All these things that you are doing, that are going to be your business. Designated partner. Designated partner means any partner designated as such pursuant to section 7. We'll be seeing section number 7. Any partner which has been given as the designation of being the partner of that LLP will be your designated partner. Entity. Entity means what? Any body corporate and includes for the purpose sections 18, 46, 47, 48, 49, 50, 52 and 53 of a firm set up under the Indian Partnership Act 1932. So entity means any body corporate and also includes these sections that a firm set up under the Indian Partnership Act. So we will be seeing those sections too. Financial year, your financial year in relation to LLP is the same as for the normal other entities. 1st April 1st April to 31st March of that financial year. However, in case of LLP incorporated after 30th day of September of a year, financial year may end on 31st day of March of the next following that year, of the year following next following that year. Okay. So if you even start after 30th day of September, then also it will be applicable till the 31st March of that next year, next following year. Not that particular year, of the next following year. Here it was of the following year. So here if we see the normal LLP, it starts from 1st April 2020 to 31st March 2021. But here in this, if we start on 10th of October 2020, so it will be a year completing on 31st of March 2022. Okay, because you've started in the middle of the year, so it will be ending on 31st day of March of the next following year, not the following year but the next following. Let's see an example. If a LLP has been incorporated on 15th October 2019, then in the financial year, then its financial year may be from 15th October 19 to 31st March 21. Next following year. Okay, if you have started after September, if we start the LLP, then it will be the next financial year, next following year. The Income Tax Department has prescribed uniform financial year from 1st April to 31st March of next year. In keeping the view of income tax law, the financial year for LLP should always be from 1st April to 31st March. As per income tax, your financial year will be 1st April to 31st March only. For the accounting purposes, you will take this as next following financial year end, because here as per the law it is said that if you start a partnership after the September, then you will be taking it in the next following financial year end. Foreign LLP. It means LLP formed, incorporated and registered outside India, which establishes a place of business in India. It's a foreign LLP. That means it is registered in foreign, but it has a place of business in India. It establishes a place of business in India. Limited liability partnership. Limited liability partnership means a partnership formed and registered under this. What is agreement? It means any written agreement between the partners of the LLP or between the LLP and its partners, which determines mutual rights and duties of partners and their uh, rights and duties in relation to LLP. Agreement is whatever are the rights and duties of the partners towards the LLP, and LLP's rights and duties towards the partner is mentioned in the limited liability partnership agreement. Okay, let's see who is a partner. Partner in relation to LLP means any person who becomes a partner in the LLP in accordance with the LLP agreement. A person who becomes partner in the LLP in accordance with the LLP agreement will be called as the partner of LLP. Small limited liability partnership. It means a limited liability partnership contribution of which does not exceed 25 lakh rupees. This you need to remember. They can ask you what is a small limited liability partnership. So you should be able to write down these 3 points, right? So if they ask you the contribution of which does not exceed 25 lakh rupees or such high amount not exceeding 5 crore as may be prescribed. So for a small limited liability partnership, you have to have your contribution between 25 lakhs to 5 crore. Turnover, it should not exceed 25 lakhs. But if they have prescribed that it can exceed up to 5 crore, not exceeding 5 crore, then also it will be considered. The turnover of which, as per the statement of accounts and solvency of immediately preceding financial year, does not exceed 40 lakh rupees or such higher amount, not exceeding 50 crore rupees as may be prescribed. So if they have given a prescribed limit that it can be up to 25 crore, they can change the limit. But the basic limits are 25 lakh for contribution, and the turnover in the immediate preceding financial year should not exceed 40 lakh. They can extend these limits. 25 lakh can be extended to 5 crore and 40 lakhs can be extended to 50 crores, which meets such other requirements as may be prescribed. If any other requirements are mentioned, they should also be met and fulfills the terms and conditions as may be prescribed. The LLP should fulfill all the terms and conditions as may be prescribed. Clear till here? The definitions are clear to you people?
Yes, ma'am.
Everyone?
Yes, ma'am.
Now, we'll see why this other partnership act is not applicable. Okay. Save as otherwise provided, the provisions of Indian Partnership Act 1932 shall not apply to LLP. As it is said, otherwise provided. If it is provided in any other law, the provisions will apply. Otherwise, the application of this Indian Partnership Act provisions will not be there on LLP. LLP will not be bound by the provisions of the Indian Partnership Act 1932. Partners, any individual or body corporate may be a partner in LLP. So Mr. A can become a partner and A and company can also become a partner, person or a body corporate. However, an individual shall not be capable of becoming a partner of LLP if he has been found to be of unsound mind by the court or competent jurisdiction, he is undischarged insolvent, or he has applied to be adjudicated as insolvent and his application is pending. Now, 3 cases the individuals cannot apply, where the individual is found to be of unsound mind by the competent court, or if he is an undischarged insolvent. This person is an insolvent and he has not discharged his liability, or if a person is adjudicated as insolvent and his application is pending. If some people have claimed, okay, this man does not have money, this is insolvent, they go and file a complaint with it, and that application, that complaint is pending, that person also cannot become the partner of LLP. Okay. Minimum number of partners. Every LLP shall have at least 2 partners. At least 2 partners is required for LLP. If at any time the number of partners of a LLP is reduced below 2 and the LLP carries on business for more than 6 months, while the number is so reduced, the person who is the only partner of the LLP during the time that it carries on business after those 6 months and has the knowledge of the fact that it is carrying on business with him alone shall be liable personally for the obligations of LLP incurred during that period. Now, if there are two partners in an LLP and one of the partner decides to retire, then how many partners will be left? Only one. And if that one partner is aware that for the next 6 months also, I am only going to be the partner, then that partner will be entirely personally liable for all the acts of LLP. If LLP has to pay 10 crore to people, this person has to bring the money from his home. There he will be personally liable. Okay. Clear till here? Let's go ahead. Designated.
Ma'am, I have a doubt, ma'am.
Yeah, sure.
Ma'am, in the definition of body corporate, what is the corporation soul, ma'am?
Yeah, corporation soul. We'll write the definition of it. And for save otherwise also write the definition. Okay. So for corporation soul, you can consider that like if it is an official position having a separate legal entity. Any officer having a separate legal entity will be considered as your corporation soul. Small company or simple like one person like proprietor kind of thing will also be considered over here. You can say like earlier it used to be this situation like bishops and the crowns. Have you heard about this lords?
Court session, ma'am.
Sorry.
During court session, we
Yeah,
used to
like
do.
you might have heard about bishops. Have you heard this word bishops?
Yes, ma'am. In court
So
they
they
used.
they are called as the corporation souls. Like they are the corporation souls. One person is running the entire thing. Like we know about the kings and lordships kind of thing. That is considered as your corporation soul. Clear?
Yes, ma'am.
Yes, ma'am.
Like one person is heading the entire corporate office. That is corporate position. That is called as your corporation soul. And one more thing you write down, save otherwise. Like for understanding purpose, it is except to the extent of specific provision made. Write down except to the extent of specific provision made. Except to the extent of specific provision made. So if any other provision is made that which makes some of the Partnership Act provisions applicable to LLP, they will be considered. Or else means save otherwise. No provisions of Partnership Act will be applicable to LLP Act. Any more doubts? Should we go ahead?
Yes, ma'am.
Okay. Every LLP shall have at least 2 designated partners who are individuals. At least one of them shall be a resident. So designated partners, they have said every LLP should have at least 2 designated partners who are individuals and at least one of them shall be resident. So your designated partners should be resident. One of them should be resident. If in LLP all the partners are body corporates or in which one or more partners are individuals and the body corporates, at least 2 individuals who are partners of such LLPs or nominees of such body corporates shall act as designated partner. Who will act as designated partner? Only individuals or nominees of body corporate. Person can only act. Person means in our normal definition, person is a human being, right? Human being can act as a designated partner. So it can be LLP partners like who are individual, LLP partners individual, or they can be nominee of body corporates. They will act as the designated partners. Okay, 2 designated partners are compulsory and one should be resident in India. Now they have given us a definition of resident. For the purpose of this section, the term resident in India means a person who has stayed in India for a period of not less than 120 days during the financial year. You will learn in the income tax, resident in India, different definition. For this act, you need to remember that this person should stay in India for not less than 120 days in a financial year. He has to be there in India for 120 days or more. 120 is also qualifying limit. Let's see an example. There is an LLP by the name Indian Helicopters LLP having 5 partners named Mr. A non-resident, B non-resident, C resident, Miss C resident, Miss D resident, and Miss E resident. In this case, at least 2 should be named as designated partners, out of which 1 should be resident. Hence, Mr. A and Mr. B are designated, then it will not serve the purpose. A and B both are non-resident, so they can't be designated partners. One of the designated partners should be there out of Miss C, Miss D, and Miss E. So you can make a combination of Mr. A, Miss C, like this one, or you can take Miss D, Mr. A, Miss D, and Miss E. Or else you can make a combination of Mr. B, Miss C, Miss D, or Miss E. Right? So this can be a combination. They can be designated partners. Or else you have the option of C and D, D and E, and C and E. These are also few options available. You can also make C and D, D and E, and C and E. These people can also become the designated partners. Okay. I hope till here we are clear.
Yes, ma'am.
Let's see what are characteristics of LLP. Essential elements and characteristics are something which they usually ask you in LLP type of questions. Now, LLP is a body corporate. We saw the definition of body corporate includes your LLP. Perpetual succession, that means the liability is limited. So even if the people, like the partners die, the LLP will not come to an end. Separate legal entity, we have seen that it has a separate legal entity. Then we saw mutual agency, mutual agreement should be there between all partners. LLP agreement is to be made. Artificial legal person, it is a separate legal entity. That means it is an artificial legal person. Common seal, they will have a common stamp. Limited liability, that's where the chapter revolves. Management of business, business is managed by the partners. Minimum and maximum number of partners, we learned that the minimum number of partners over here is 2. Business for profit only, they do the business only to earn profit. There is no charity purpose over here. Investigation can happen. Then we have compromise or arrangement. We may come to a compromise or arrangement. Conversion can be done into LLP. Partnership firm can convert into LLP. Firm can convert, or your company can convert, or your unlisted public company can also convert into LLP. E-filing of documents. Documents are required to be filed online. And there are also foreign LLP. Okay, I just gave you a brief about characteristics. Let's see them in detail. LLP is a body corporate. Section 21D of the LLP Act 2008 provides that LLP is a body corporate formed and incorporated under this act and is legal entity separate from that of its partners and shall have perpetual succession. Therefore, any change in partners of LLP shall not affect the existence, rights, and liabilities of LLP. LLP is a body corporate, it's a separate entity, and any changes in any of the partners, they are not acting as partners. Still, the LLP will continue, it will have the rights and liabilities of LLP. Section 3 of LLP Act provides that LLP is a body corporate formed and incorporated under this act and is a legal entity separate from that of its partners. Partners are a separate entity and LLP is a separate entity. Perpetual succession. LLP can continue its existence irrespective of change of partners. Even if a death happens or someone becomes insane, retirement happens, insolvent partners become insolvent, has no impact on LLP. LLP will still continue. It is capable of entering into contracts and holding property in its own name. LLP can enter into contracts and it can hold property in the name of LLP. They get a separate PAN registration for the LLP also. Same as for partnership. They also get a separate PAN, and also for LLP, they get a separate PAN number. Then we have your separate legal entity. LLP as a separate legal entity is liable to the full extent of its assets, but liability of the partners is limited. You can access all the assets of the entity, but liability of partners is limited to their agreed contribution. If they said all of them are going to contribute 1 CR, so maximum that they will pay to the company is 1 CR. More than that, they will not pay to, they will not pay anything to the company. In other words, creditors of LLP shall be creditors of LLP alone. If some people are creditors of LLP, they are going to recover the money from LLP. They will only recover from LLP. They can't ask partners to bring the money from their home. Mutual agency. No partner is liable on account of the independent or unauthorized actions of other partners. Thus, individual partners are shielded from joint liability created by another person's wrongful business decisions or misconduct. In other words, all partners will be the agents of LLP alone. No other partner can bind the other partner by his acts. In partnership, what we learned, partner can bind the other partner by their acts. But in LLP, what happens? Partners will bind only LLP for their acts. If something goes wrong, LLP will be responsible. Other partners will not be responsible because here the liability is limited. They need to have a mutual agreement between them, and that should be independent, and unauthorized actions of these partners should not be done. LLP agreement. Mutual rights and duties of the partners with the LLP are governed by an agreement between the partners. The partners have to do some agreement where mutual rights and duties of the LLP are mentioned. And it provides flexibility to partners to devise the agreement as per their choice. They can make the agreement as per their choice. Whatever things they want to include in the agreement, they can include. In absence of such agreement, mutual rights and duties shall be governed by the provisions of LLP Act 2008. If they do not get into an LLP agreement, whatever like rights and duties are given in the LLP Act, they will be binding on all the partners and the LLP firm. Okay. Then we have our artificial legal person. A LLP is an artificial legal person because it is created by a legal process and is clothed with all the rights of an individual. So your LLP will be a separate legal person and it will have all the rights just like an individual. It can do everything which any natural person can do, except of course that it cannot be sent to jail and cannot take an oath, cannot marry or get divorced, nor it can practice a learned profession like CA or medicine. So artificial legal person can sign the documents. They will have a digital signature. You might not be aware of this concept, but now what happens is if you want to sign a document, you can generate your digital signature. So LLP can generate a digital signature and sign the documents, but they can just act like a individual. They can't do all the things like a natural person. They can't marry someone, they can't divorce someone, they can't study and they can't take the degree like CA or medicine or LLB, your law, etc. They cannot be sent to the jail. You can't send the LLP to a jail, and it cannot take a oath. Okay, these are some like relevant things that they have mentioned over here for artificial legal person. A LLP is invisible, intangible, immortal. It can be system issues. It can be dissolved by law alone. If you want to dissolve a LLP, it needs the permission of court, but not fictitious because it really exists. It is really exists. So you can't say that LLP is not into existence. We can't see LLP, so let's just dissolve it. Okay. LLP is invisible, intangible, immortal, but not fictitious because it really exists. It is not fake because it really exists, and there is an entity having the PAN effect. Next, we have is common seal. LLP, being an artificial person, can act through its partners and designated partners. LLP will act through its partners and designated partners. LLP may have a common seal if it decides to have one. They can make a common seal for LLP. Thus, it is not mandatory for LLP to have a common seal. It is not compulsory to have a common seal. If you want, you can make it. It shall remain under the custody of some responsible official, and it shall be affixed in the presence of at least two designated partners of LLP. So this, what you prepare as the common seal of the LLP, it shall remain under the custody of some responsible official. It should be taken care, and it should be there kept with a designated partner who is responsible. At least two designated partners of LLP should be present while generating the common seal. Okay. Are these 7 points clear to you people? Any doubt in this first 7 points? Go through it once. If any doubt, please ask.
Ma'am, why can't the LLP can be the agent of others?
Sorry, agent of others. Because if it will become agent of others, and one person, like one of the partner does something wrong, then they will have to tell the other partners to pay the money. That is why it is not agent of others. Partners can be agent of LLP. LLP will be like LLP is a different separate entity. Agent cannot be any entity. Agent can't be a body corporate. Agent can be an individual. So you can say that partners are the agents of LLP, but they are not agents of other partners, because if something goes wrong, if agent does something wrong, principal has to pay. So if one of the partner does something wrong, other partners will have to pay. That is not what is applicable in LLP. That is why this LLP came into picture, because other partners don't want to pay anything.
Okay, ma'am.
Okay, clear?
Yes, ma'am.
Should we go ahead, everyone?
Yes, ma'am.
Okay, let's go ahead. Limited liability, we have seen this definition. Every partner of LLP is for the purpose of business of LLP, agent of LLP. Every partner is agent, but not of other partners. The liability of the partners will be limited to their agreed contribution in the LLP. Whatever amount they have agreed, that much only they are liable to pay. If someone does something wrong, the other partners will not pay, because they are liable to pay only till their agreed contribution. Such contribution may be of tangible or intangible nature, or both. They can either bring a land or building, or either they can put their services, they can give their, what do you call it, professional services, they can give their knowledge and expertise. That is also considered as a contribution. Professionals like engineering consultant, legal advisors, and accounting professionals are afraid of entering into business due to unlimited liability. Hence, LLP Partnership Act provides an avenue for these professionals to limited liability partnership firms which restrict their liability to the agreed amount. This has encouraged professionals to form LLP. Now, as I explained you earlier also, people are scared to enter into partnership because their liability is unlimited. So now these professionals like engineers, consultants, legal advisors, accounting professionals, all can enter into LLP because their liability is limited. Next is management of business. Partners of LLP will be managing, but only the designated partners are responsible for legal compliance. When legal compliances come into picture, they're asking for presentment in the court, etc. Then your legal compliances will be done by the designated partners. Only designated partners are responsible for legal compliance. Minimum and maximum number of partners. Every LLP shall have at least two partners and shall also have at least two individuals as designated partners, of whom at least one should be a resident in India. There is no maximum limit to the partners in LLP. Any number of partners can be there in an LLP. Okay.
Yes, ma'am.
Business for profit only. essential requirement of forming LLP is carrying on a lawful business with a view to earn profit. LLP cannot be formed for charitable or economic purpose. You can't form it for charitable or economic purpose. Central government shall have powers to investigate the affairs of LLP by appointment of competent authority for the purpose. LLP provisions or LLP is following all the rules or regulations or not can be checked by the central government. They can appoint any people to check the liability and to check the correctness of your LLP. Compromise or arrangement. Any compromise or arrangement, including merger and amalgamation of LLPs, shall be in accordance with provisions of LLP Act 2008. Any merger is happening of two LLPs or any compromise is happening, change in PSR is happening, all these will be covered under the LLP Act 2008 for the companies registered under the LLP Act 2008. Okay. Conversion into LLP, a firm, private company, or an unlisted public company would be allowed to be converted into LLP in accordance with the provisions of LLP Act. Any firm, any private company, or unlisted public company can get converted into the LLP partnership. Okay. I did it. E-filing in e-filing of documents. Every form or application of document required to be filed or delivered under the Act and rules made thereunder shall be filed in computer readable or electronic form on its website www.mca.gov.in and authenticated by partner or designated partner of LLP by the use of electronic or digital signature. So as I told you, there are digital signatures available. Companies, LLPs need the digital signature. So they will generate a token number. They will have a password and an ID for that. That will be their signature, digital signature. They have to file all their documents like all the profit and loss statement, bank balances, bank statements, or any balance sheet statements. All these is to be filed on MCA website. Foreign LLP Section 21M defines foreign limited liability partnership as a limited liability partnership formed, incorporated, or registered outside India, which establishes a place of business within India. Foreign LLP can become a partner in an Indian LLP. So, foreign LLPs can become a partner in Indian LLP, and foreign LLPs are those which are made outside India, which are formed outside India, but they have a place of business in India. Okay. Are all these characteristics clear to you people? Are these characteristics clear to you people?
Yes,
Okay, right. So further we have our advantages. You want to continue or need any 5-10 minutes break because it's almost an hour. So if you get bored, tell me, we'll take a break of 5-10 minutes. Sorry,
10 minutes.
10 minutes. Okay. It's 3:55 now. Let's resume at 4:05. Right? We'll resume at 4:05 now. So LLP form is a form of business model which is organized and operates on the basis of agreement. You have an agreement and on the basis of that only your LLP is constructed. So it helps to manage the things very well compared to your partnership where there are chances that it can be an oral or a verbal type of agreement. Provides flexibility without imposing detailed legal and procedural requirements. It is flexible and there is not much legal and procedural requirements compared to the companies. It is easy to form. All partners enjoy limited liability. Flexible capital structure is there. Okay, you can make any amount fixed as your capital. There is no specific capital restriction on you, because in companies we see there are capital restrictions like as much as written in your authorized capital will be the capital maximum you can raise in the entire lifetime. If you want to change, then you have to amend the articles of association. Easy to dissolve. It is very easy to dissolve. You have to take the permission from the courts and get it dissolved. Okay. The camera is not visible to me. Now it is. Yeah. Now we learned what are the advantages of LLP. Let's see incorporation of LLP. Most important document need for incorporation for the registration is incorporation document. You need to make an incorporation document of LLP. For LLP to be incorporated, one or more persons associated for carrying on a lawful business with a view to profit shall subscribe their names to an incorporation document. They have an incorporation document where two people have to mention their names that we are going to run this business. Incorporation document shall be filed in such a manner and with such fees as may be prescribed with the registrar of the state in which the registered office of the LLP is to be situated. So wherever the registered office is going to be situated, suppose you make the registered office in Delhi. So with the registrar of Delhi, you have to file your incorporation document. I'll just see if we can get an incorporation document for you. See, I'll just show you people. So somehow like this, it will appear your SRN number is to be given like then your CIN number. If you are a if you are a company, body corporate, you have to mention the CIN number. LL pin they will give you, proposed name, what is the name and comments, etc. This is your document for your LLP registration, incorporation registration. Okay. Then statement to be filed. This your LLP incorporation document should be filed with a statement along with your incorporation document. There shall be filed along with the incorporation document a statement in the prescribed form. Whatever type of format they will give us, with that you will have to form a statement, and that is going to be filed with your incorporation document. Now here they will ask you what is your status, what kind of person you are. If you are a chartered accountant, etc., and they are forming a LLP, that you have to specify name of the person who is becoming the LLP partner, then place of business, residence of the partners. All these things will be made by either an advocate or a company secretary or a chartered accountant or a cost accountant who is engaged in the formation of LLP. This statement has to be filed, made by these people. An advocate can make, a company secretary, a chartered accountant, cost accountant can make. By anyone who subscribed his name to the incorporation document. Any partner can also make your statement that all the requirements of this act and the rules made thereunder have been complied with. In that statement, you have to mention all the requirements of the act and rules that are there. We are complying with them. We are following them. In respect of incorporation and matters precedent and incidental thereto, whatever matters will be there with the incorporation that we have already complied or we are going to comply in the near future that are incidental that will have to comply are to be mentioned in your statement, which is going to be filed with your incorporation document. Okay. Now, these are two compulsory statements which you need to file so that you can get your partnership LLP business registered. And then only your further procedures will start for the functioning of your LLP. Okay. Incorporation document shall, one second. Incorporation document shall be in a form as may be prescribed. They'll give you a form, and in that manner only you have to make your LLP incorporation document. We saw a sample. In the similar manner, they can have your incorporation document. State the name of the LLP. You have to write the name of LLP. What business you are going to do. If you are going to sell crockery. So you have to mention that we are going to go into the business of crockery, manufacturing of leather. So manufacturing of leather products. All these things you have to mention. Proposed business of LLP is to be mentioned. Name is to be mentioned, and the form they will give us. State the address of the registered office of LLP, where the LLP will be working. Then state the name and address of the persons who are to be the partners of LLP on incorporation. Who all will be the partners of LLP, their names are to be given, name and address. Name and address of person who are designated partners of the LLP on incorporation. So your partners details and designated partners, every detail has to be given. Contains such other information concerning the proposed LLP as may be prescribed. They may ask you for the PAN of the LLP. Then what is the date of incorporation of LLP PAN? When did you get it registered? All these things also they will ask. If a person makes a statement as discussed above, which he knows to be false or does not believe it to be true, shall be punishable with imprisonment for a term which may extend to 2 years. So, if any of the information you are providing here is false, then you may be liable, you may be punishable with an imprisonment which may extend to 2 years. So, like from 0 months to 2 years, it will be a punishment. 0 months to 2 years, and with a fine which shall not be less than 10,000 but which may extend to 5 lakh. So a fine will be there from 10,000 to 5 lakh rupees. Any amount can be there. Minimum is 10,000 fine. Is this clear to you?
Yes, ma'am.
Incorporation by registration. When the requirements imposed by clauses B and C of subsection 1 of section 11 are to be complied with, the registrar shall retain the incorporation document, and unless the requirement imposed by clause A of the subsection has not been complied with, he shall not within a period of 14 days register the incorporation document and give a certificate that LLP is incorporated by the same name specified therein. Now what they have said, we have to see the section number 11, clauses B and C of subsection 1. Let's go back to 11 subsection 1. That was related to your incorporation. Now, what they have said, you have to file the incorporation document in 11(1)(b). They have said incorporation document should be filed in such a manner with surface and statement to be filed. You have to comply both these things. If you do not comply with this, what they have said, when the requirements imposed by this section have been complied, when you follow these compliances, when you make the incorporation document and you give it to the person, then you file the statement also, then registrar shall retain the incorporation document, and unless the requirement imposed by clause A of subsection has been complied with, he shall within period of 14 days register the incorporation document. When you give the incorporation document, it will take 14 days for the registrar to give you the incorporation document and the LLP certificate. They will give you a LLP certificate where they will say that now you are a LLP. It will take maximum 14 days after you file the incorporation document and the statement file. Registrar may accept the statement delivered under clause C of subsection 1 of 11 as sufficient evidence that the requirement imposed by clause A of subsection has been complied with. If you are filing this statement and the incorporation document, then it will consider you are doing all the compliances for becoming a LLP. Certificate issued under clause B of subsection 1 shall be signed by a registrar and authenticated by his official seal. So your registrar has to sign the incorporation certificate, and an official seal will also be given. Certificate shall be conclusive evidence that the LLP is incorporated by the name specified therein. Certificate says that yes, this is a LLP and it has been incorporated with this name. Okay. Is section number 12 clear to you all?
Yes, ma'am.
Registered office of LLP and change therein. Every LLP should have one registered office, and this address of the office is also to be given to the registrar of company. Now, every LLP shall have a registered office to which all communications and notices may be addressed and where they shall be received. So to this office, any notice is to be given, communication is given by any of the department will be sent. Any document may be served on LLP or a partner or designated partner thereof by sending it by post under a certificate of posting or by registered post or by any manner as may be prescribed at the registered office and any other address specifically declared by the LLP for purpose in such form and manner as may be prescribed. So any document is to be sent, any bill is to be sent, any communication notice by the department, any order the department wants to send you, that will be sent on the registered office place of business which LLP has given. And if they don't want it on that place, they can give a specific different address also. LLP may change the place of its registered office and file the notice of such change with the registrar in such form and manner as subject to such conditions as may be prescribed, and any such change shall take effect upon such filing. If they want to change their office from Delhi to Chennai, if they want to change the office from Delhi to Chennai, so they have to file the change, notice of change with the registrar, and that will be duly accepted. If the LLP contravenes any provisions of this section, LLP and its every partner shall be liable to a penalty of 500 for each day during which the default continues, subject to a maximum of 50,000 for the LLP and its partner. So if you are doing anything wrong in the LLP Act, then you will have to pay 500 rupees penalty every day. And the maximum penalty that can go is 50,000. So you can see that 100 days of default is allowed. Like not allowed, but you have the maximum penalty for 100 days of default. And the liability will be same on LLP and its partner. Partner will also have to pay 50,000 and your LLP will also have to pay 50,000. If the default is of LLP, LLP will pay. If it is the fault of partner, partner will. Right? Now, if you get the registration, it is that suing and being sued, that you can file a case against any of the parties and other parties also get the right to file a case against you people. Like if LLP does something wrong, the creditors or the bank people can file a case against them because that LLP is registered. So it is important that the LLP is registered. And if someone does wrong to you, debtors don't pay you money, you can file a case in the court. Right. Then on registration, a LLP by its name be capable of. What is it capable of? Suing and being sued, that we learned. Acquiring, owning, holding or developing or disposing of property, whether movable or immovable or intangible. You get the right of buying any property, either movable property or immovable property. If you need a truck for the business, you can buy that because now you are a registered LLP. If you need a land or building for the business, you can get it because now you are registered LLP. Having a common seal, if it decides to have one, if they want that there should be a common seal for the LLP, ABC LLP, so they can file it with the registrar of companies, registrar of firms, and say that we need a specific common seal for our business. Doing and suffering such other acts and things as bodies corporate may lawfully do and suffer. So if any of the requirements are there for the body corporate, they have to, LLP also has to follow the same. And if LLP has to suffer anything or it needs anything lawfully to be done, it is going to do same way as the body corporates do it. Is this section clear?
Yes, ma'am.
So registration is important because you can get all the benefits just like a body corporate, and you also have to do all the compliances similar to a body corporate. You can go for a common seal because now you are registered. You can sue other people and other people can also sue you if you have done something wrong, and you can purchase any type of property. Next, next is LLP name. Every limited liability partnership shall have either the words limited liability partnership or the acronym LLP as the last words of its name. So with the name, they should have LLP. As I wrote over here, ABC LLP. right? ABC LLP, ABCD LLP, or they can write limited liability partnership entire words. No LLP shall be registered by a name which in the opinion of central government is undesirable. If the central government feels that this name is undesirable, you can't enter into with that name. Identical or too nearly resembles to that of any other LLPs or a company or a registered trademark of any person under the Trademarks Act 1999. Now, if the same name is taken by other people, you can't take it. If someone takes the name ABC Enterprises, there are 10 ABC Enterprises, you can't take that name. You have to make it something unique. ABCQ LLP. So you have to make something unique out of it. Is this section clear? Name?
Yes, ma'am.
மேம் இப்போ கம்பெனி நேம் பக்கத்துல எல்டிடின்னு வந்தா கூட லிமிடெட் தானே?
Sorry, could you repeat?
மேம் நேம் பக்கத்துல எல்டிடின்னு வந்தா கூட லிமிடெட் தானே?
LTD is used for the companies because they are limited. Here we are using LLP, that is limited liability partnership. Your LTD comes over here. Like undoubtedly the meaning is same, so we use specific acronym that has been given LLP. For the normal partnership, they have not given anything. So what they people use is ABC and company. You might have seen in the previous lectures also, I gave you the example ABC and company, because and company is not a specific acronym for the private limited or public limited. Anyone can use it. Okay.
Yes, ma'am.
Reservation of name. A person may apply in such form and manner as accompanied by such fee as may be prescribed to the registrar for the reservation of a name set out in the application as name of a proposed LLP or name to which a LLP proposes to change its name. Now, you have the power to reserve the name. You can say that this is my name. I want to reserve it. You have to give some money, suppose 500 rupees you pay, and you tell them we want ABCQP LLP. This is going to be our name of the proposed LLP, the LLP that we are going to form. Or we can say that earlier it is ABCQ LLP. Now we want to make it ABCQP LLP. So you can also ask in that manner. Like you can ask them for reserving the name. Upon receipt of application under subsection 1, on the payment of prescribed fees, I told you have to pay some prescribed fees that can be around 500 or something. Registrar may, if he is satisfied, subject to the rules prescribed by central government in the matter that the name to be reserved is not one which may be rejected on any ground referred to in subsection 2 of section 15, reserve the name for a period of 3 months from the date of intimation of register. If they feel that this name is not debatable or no one will object this name is available, they can reserve the name for you people for only 3 months. For 3 months, they will reserve the name. Okay. Is section number 16 clear?
Yes, ma'am.
Change of name of LLP. Notwithstanding anything contained in section 15 and 16, if through inadvertence or otherwise a LLP on its first registration or on its registration by a new body corporate and its registered name is registered by a name which is identical with or too nearly resembles to that of any other LLP or a company or a registered trademark of a proprietor under the Trademarks Act 1999, as is likely to be mistaken for it, then on application by such LLP or proprietor referred in clause A and B, respectively or a company, central government may direct that such LLP to change its name or new name within a period of 3 months from the date of issue of such direction. Now, if the registrar feels that the name that he has given to your LLP is very common, it resembles to other name. Now, I'll take an example. We have Reliance and the other is Reliance, right? Reliance and Reliance. These are very similar words. Like if you pronounce it, Reliance, Reliance, like very similar words when we pronounce it. So what happens? Reliance goes to the registrar and says that this new Reliance company is having the similar name as us, and this is affecting our trade and commerce. They are doing the same business, and people are not buying from us, they are buying from the Reliance. That is why what you do is you just go and direct them to change their name. So then the department, the registrar of companies, will give a direction to Reliance and tell them to change their name within a period of 3 months. How much time will be given to them? Again, 3 months time period will be given, and from the date of such direction given, they will change their name. Okay. It is further provided that an application of the proprietor of the registered trademarks shall be maintainable within a period of 3 years from the date of incorporation or registration or change of name of LLP under this Act. If an application has been made by a registered trademark, as I told you, Reliance will go and say they are having the same trademark as us, they are having the similar symbol as us, so we need the change for it. So that is maintainable for 3 years. For 3 years, they can ask you like not to change this name, not to take the similar name. Where a LLP changes its names or obtains a new name under subsection 1, it shall within a period of 15 days from date of such change give notice to the change, give notice of the change to registrar along with order of central government, and shall carry out necessary changes in certificate of incorporation within 30 days of change in certificate of incorporation. Such LLP shall also change its name in LLP agreement. So if the change is required, within a period of 15 days, you have to inform the registrar that central government has asked to change the name, and within 30 days, you have to get it changed on the certificate and your agreement. Okay. So 30 days is the maximum time period given. You have to get it changed in the certificate of incorporation and also in your LLP agreement. Then we have, if the LLP is in default in complying with any direction given under subsection 1, the central government shall allot a new name to the LLP in such manner. So any default has happened in complying with any direction given in section number 1, central government shall give you a new name to the LLP in such a manner as may be prescribed, and the registrar shall enter the new name in the register of LLP in place of old name. If they are changing the name, this will be changed in the register also. Old name, and issue a fresh certificate of incorporation. When the name is changed, you get a fresh certificate of incorporation with new name, which the LLP shall use thereafter. And after this, whatever name is to be used, this will be used as the new name. Nothing contained in this subsection shall prevent LLP from subsequently changing its name in accordance with provisions of section 16. If the LLP wants, they can change their name whenever they want. After ABQP, if they just want it AB, so they can get it AB also done, right? If they want to change, they can subsequently also change it. Is this clear to you people? The section change of name.
Yes, ma'am. Yes.
Right? This was almost what LLP is said. Now we have the differences. We'll be discussing them, but I thought let's just take a recap that you are clear with everything. Right? We are clear till here.
Yes, ma'am.
Okay, let's start with the difference with other forms of organizations. We'll see how LLP is different from partnership. First of all, the basic difference is LLP is governed by the Limited Liability Partnership Act 2008, and partnership is governed by the Indian Partnership Act 1932. Then LLP is a body corporate. Partnership is not a body corporate. You have to remember this. Partnership is not a body corporate. They can ask you this type of difference between. That will be a 3-4 marks question. Very much like easy thing you can write. Separate legal entity. It is a legal entity separate from its member. Group of persons with no separate legal entity. Here this partnership is not a separate legal entity. Partners are still liable. Creation. Legal process of registration under the LLP Act, and partnership is created by agreement between the partners. Registration is mandatory. Here it is voluntary. We learned in the previous class. Only registered partnership firm can sue the third parties, and here LLP can sue and be sued in his own name. If LLP is there, you can sue the LLP, and LLP can also sue other people. Perpetual succession. death, insanity, retirement, or insolvency of the partner does not affect the existence of LLP. If the LLP is there, it can still exist even if the partner dies, if partner becomes insane or retires. Partners may join or leave, but its existence continues forever. Here, death, insanity, or retirement or insolvency may affect its existence. It has no perpetual succession. It cannot succeed after all partners have died. Name of LLP to contain the words LLP as a suffix. No guidelines. Partners can have any name as per their choice. They can do any of the names. That's why I told you ABC and company. That is what they use it, because they don't have any guidelines. They don't have any restrictions on them. Liability of each partner is limited in LLP to the extent of agreed contribution. Here, liability is unlimited. It can be extended up to the personal assets of the partners. Partners will have to use their personal assets, their home, their house, their property, etc. to pay the debts. Each partner can bind the LLP by his own acts, but not the other partners. Here, LLP partners cannot bind other partners. Here, each partner can bind the firm as well as other partners. You can bind other partners also by your acts. Designated partner, at least 2 designated partners and at least one of them shall be resident of India. There is no provision of designated partner over here. Common seal, it may have its common seal and as its official signature. So they can get a common seal as their official signature. Here, no such concept of common seal is there in your partnership business. Okay. Here, there's no common seal. You can get a common seal. Legal compliances. Only designated partners are responsible for all the compliances. Here, all partners are responsible. In partnership, all the partners will be responsible for all the compliance and penalties. Annual filing, annual statement of accounts, statement of solvency, that the firm is solvent, all the partners are solvent. Annual return with the registration of LLP every year. Partnership firm not required to file any annual documents with registrar of firms. They don't have to form any documents, or they don't have to give any sort of documents to the registrar of firms. Okay, I hope this difference is clear to you people. There are few more points. Foreign partnership, LLP can have foreign nationals and they can become a partner in LLP. Sorry. Foreign nationals can become a partner in LLP. Foreign nationals cannot become a partner in partnership firm. If you have a normal partnership firm, foreign nationals cannot become your partner. But in LLP, foreign nationals can become your partner. Minor as a partner, minor cannot be admitted to the benefits of LLP. You cannot admit minor as a partner to the LLP. Here, minor can be admitted only till the benefits of partnership with prior consent of existing partners. All the existing partners need to give their consent for this partnership to for this minor to be admitted as partner. Okay, is this one clear? Is LLP versus partnership clear to you people?
Yes, ma'am.
Yes, ma'am.
Now, next is your company versus the LLP. Now, company will have greater compliances, or you can say more compliances rather than the LLP. They are registered under the LLP Act and these are registered under the Companies Act 2013. Earlier, it was Companies Act 1956. Person who contribute to LLP are known as partners of LLP. Here, person who invest the money in the shares are known as the members of company. Tomorrow, we'll be learning all the concept of shares. So now, for now, you have to remember that person who invest in money in the shares of the company are the members of that company. Internal governance structure of LLP is governed by contract agreement between the partners. Partners can enter into a contract and then they can decide what will be the governance, how much money is to be invested, etc. They will determine. Internal governance of a company is regulated by statute. Now your statute regulates. Tomorrow I'll explain you how your share capital that you want to fix. Like if they want LLP, they can fix a capital of 4 CR. and that will be distributed among 4 partners, A, B, C, D, right? Here, they will make an authorized capital. Then people will subscribe to that capital. People will be paying that money to the capital. All these things work in a limited liability company. Name of LLP has to contain LLP as their suffix. Name of public company to contain the word limited. Private company to contain the word private limited. Okay, public companies need to put the word limited. Private companies need to put the word private limited. Public companies are those in which government is also involved. Government has the share in the share capital. Government has a stake in their share capital. In the number of partners, minimum there are 2 partners required, and maximum no such limit is given in the sorry. The partners of LLP can be individuals or body corporate through the nominees. Any one of them, like body corporates through their nominees, can become the partners, or individuals can become the partners. For a limited liability company, private limited, 2 members are required, maximum 200. Public limited, 7 members, and there is no maximum limit. Any number can be a maximum limit. Any number of members can be there in the public liability company. Okay, public limited company. Members can be organizations, trust, any other business firm or individuals. Mr. A can also be the shareholder. A and company can also be the shareholder. A and club, like I'm just taking a name, arts club, they can also become the member. They can also buy the shares of your public listed company. Liability of partners. Liability of partners is limited to the extent of agreed contribution. Here also, liability of members is limited to the amount unpaid of shares held by them. If they hold a share of rupees 10 and they have only paid rupees 6, so their liability is rupees 4. That is the extent of the liability of the member of a company, limited liability company. Okay, write it properly for you people. Limited liability company. Amount unpaid is only the liability. Management, business of the company is managed by the partners, including the designated partners authorized in the agreement. So business of the firm is managed, instead of company, this should be firm. Firm is managed by partners and they can also be designated partners. Affairs of the company are managed by board of directors elected by shareholders. Board of directors will be managing the business and they are elected by the shareholders. You, me, who all are subscribers or the shareholders of that company will make the board of directors. Minimum number of directors or partners. Minimum 2 designated partners are required. Private company requires minimum 2 directors and public company requires minimum 3 directors. Okay. This was the distinction between a LLP, limited liability partnership, and a limited liability company, your private limited or public limited company. Okay. I hope these points are clear to you people.
Yes, ma'am.
Any
Yes, ma'am.
doubts so far in the chapter? The chapter has come to an end.
No doubt.
So, so far let me just stop the recording.